total is that those orders be vacated, the applicant be released on free bond,
Did the lower court say upon the expiry of the 3 days, what would happen?
none whatsoever. That's a lacuna in the first place. Because I want to hear I've just been served with a replying affidavit by the state. I had reached paragraph, I think, 12 as I was reading it. I would want to have at least 5 minutes to rebut.
That's fine.
Thank you.
And briefly, my lord, would wish to point out that the matter being investigated upon before the lower court is a cognizable offense. By dint of section 29A of the CPC, a warrant is not required. 29A, my lord. A warrant is not required, which would therefore state that the arrest was lawful, which was done on the 30th of June this year. And the applicant was presented before a court of law
I've taken the opportunity to read the replying affidavit, and I'm going to leave it myself on the issue on why those orders were going to be vacated, and also just spend 2 minutes on the contents there. My Lord, I think Learned Counsel was not paying attention when I was raising the fact that the orders which were granted by the lower court were issued on the basis that not sufficient information was given to the lower court and misrepresentation. The state in itself intentionally misled the judiciary to grant orders limiting the applicant's rights. And I think my submissions have been captured well. But in response to the replying affidavit, when
You're politely saying they conned the court.
yes, they did, without mincing my words, my Lord. My Lord, this replying affidavit is concerning on 3 main issues. The first, they're talking about searching of a person under Section 25, which I do not oppose to that. Police officers have a right to search a person. But when it comes to seizure of gadgets without a court order, that is an abuse of court process. The other issue, I'm pleased that they are quoting my matter that I defended, Republic versus David Ogamokaya. That is paragraph 13 of the replying affidavit. Same situation that has happened to Halima Ngache is what happened to David Mokaya. They're misrepresenting facts again on paper. Saying that the defendant, David Mokaya, was not present in the residence, yet he was. I was the attorney on record on that matter and on representing the Law Society. So they are lying again. That's perjury. Let's look at paragraph 14, 15, and 16. They are admitting that the applicant was arrested before investigations were concluded. Let's look at the case of Oscar Sudi versus NCIC, my former employer, 2020.
What is the point you're making?
The point I'm making, my lord, is that they indeed went ahead to arrest the accused person before completion of investigation and without having evidence in the first place to arrest the applicant. That goes against the tenets of Oscar Sudi versus NCIC in 2020.
Oscar Sudi versus
The National Cohesion Integration Commission, 2020. Yes. Lastly, my lord, the miscellaneous application which was signed by Officer Meto under paragraph number 7 of the supporting affidavit, the state is refusing to admit that the person whose 7 of the supporting affidavit The alleged complainant there is the head of state. That is the President of the Republic of Kenya. They are saying he had apprehension because the private jet he was using traveling in Europe was in the public domain. They are talking about the President of the Republic of Kenya. That's the complainant. That begs the question, was there a complaint that was annexed to the miscellaneous application that could have given the JO in the magistrate court sufficient confidence to issue orders that will make the public understand as to why her rights are being limited? No. Lastly, in the replying affidavit, it acknowledges all the procedural flaws being transferred from Mombasa without being booked, being brought to Nairobi, all those things. And to the fact that they never even, and they're never admitting whether they introduced themselves to the applicant. Nowhere that is silent. Article 49 has been abused as far as the applicant is concerned. And in closing, my Lord, I am pleased to hear the court is informed of the decision in petition E671, LSK versus the Attorney General. E671. Yes. LSK versus the Attorney General and the Communications Authority of Kenya. Your sister, Honorable Patricia Mande, so fit that Section 27 of the Computer Misuse and Cybercrimes Act is unconstitutional. And at that point, my Lord, I beg to ask, isn't our application valid? That is all.
I immediately follow up on that. The earliest I can give the ruling in this matter is on Monday the 6th. But I will make a pronouncement on the issue of release after the close of business today. Okay?
Most obliged.
So let me just make that direction. Okay. File, thus a ruling cannot be issued instantaneously. The learned honorable magistrate having ordered that the applicant be detained for 3 days from 1st of July 2026, this court directs that at the close of business today and for avoidance of doubt, at 5 p.m. the applicant should be released from police custody. Then number 3, ruling on Monday 6th of July 2026, and the DR is directed to avail the lower court file by noon today. Okay?
Much obliged.
So I'll give you a recent ruling on Monday on other issues.
Much obliged.
Okay.